Ladies and gentlemen, my presentation addresses a very concrete problem. As we see on the screen, title containing a very difficult issue, very serious issue, very difficult process of proving constitutional delicts in Poland, evidentiary challenges in holding high state officials accountable. So the core problem, in this way, the core problem in my point of view, based on several analytical areas. The first, the legal accountability of the highest state officials, inter alia, the principles of this accountability and the construction of their negative acting. And the second, how to prove this negative acting committed by the highest state officials and why in practice this accountability so rarely becomes real. And I will briefly present the legal framework of constitutional accountability in Poland. Then I will show how this model combining criminal procedure with constitutional mechanism works in practice. And at the end, I will propose several directions for change that may be interesting for other countries facing the problem of political allied accountability. So the Polish system of accountability of the highest officials is hybrid in nature. On the one hand, we have constitutional accountability before the state tribunal based on a special concept of what we structurally call a constitutional delict. I will explain this complicated issue in detail in the further stage of my speech. And on the other hand, we have classic criminal liability from the criminal code, which sometimes intersect, sometimes overlap with constitutionally accountability. And what is this constitutional delict? In this way, we encounter very specific legal construction, these constitutional delicts. Very important act in Poland in this area is the State Tribunal Act in Poland, which specify primary elements of constitutional accountability is. Because in our analysis, important role play the legal construction of this exactly constitutional delict. In a very short, a constitutional delict consists in a person holding one of these functions in connection with their position or within the scope of office, violating the constitutions or a statute. Importantly, this model includes unintentional violations. Pay attention that we therefore have something like sui generis accountability. At the same time, the same act may be recognized as a crime under the criminal code. It is totally different word. And there is not all. There is another issue. The next issue is the reference to the criminal procedure code as the key importance element. Article 18 of the State Tribunal Act in Poland states that in proceedings before the tribunal and before the constitutional accountability commissions, the provisions of this code of criminal procedure apply accordingly. This means that the entire constitutional accountability procedure uses classic principles of criminal procedure, as example like presumption of innocence, the right to defense, the in dubio pro reo principle, the free evaluation of evidence, and the two-instance principle. Additionally, these solutions are filtered through a system of substantive and procedural immunities, which in practice determine whether evidence in a constitutional delicts case will be collected and evaluated at all. Ladies and gentlemen, we have some shortcomings and doubts appears very concrete and actually question. Who and for? What should this system cover? The Constitutional and the State Tribunal Act indicate a very close group of persons holding the highest position in state. There are primarily the president, members of the government, heads of the most important control institutions, and some parliamentarians. The legislator assumes that their position and influence on the state justify a special, enhanced accountability regime. As we see, the issue of constitutional delict itself has been defined very broadly. It is sufficient that the person holding one of these functions in connection with their position on or within the scope of office violates the constitution or statutes, even unintentionally, as I mentioned. This means that constitutional accountability covers not only obvious abuses of power, it also covers other serious violations of the constitutional order that do not always meet the elements of a crime under the criminal code. The point is that classic criminal law protects primarily individual rights such as life, health, or property, as well as certain, of course, basic public goods. Meanwhile, many behaviors of the highest official strike primarily at the very constructions of the state, the separation of power, the principle of legality, or the fair trade standards. At the same time, the same factual situation can be assessed in parallel above a constitutional delict and a crime. A classic example is abuse of power, which violates both the Constitution and the criminal code provisions on official crimes. The State Tribunal Act then allows for cumulation. The tribunal can impose both constitutional sanction and, if necessary, of course, classic criminal penalties and measure. So, moving to the next level of our analysis, we must ask, according to what rules does the State Tribunal evaluate evidence in constitutional delict cases? The key here is the reference to the Code of Criminal Procedure, as I mentioned. The State Tribunal Act does not create its own separate evidentiary standard. It expressly requires the appropriate application of the Code of Criminal Procedure. In practice, this means that the State Tribunal uses the classic principle of criminal procedure. The presumption of innocence applies. The in dubio pro reo principle applies. The principle of realization applies. In this moment, pay attention, please, into the game enter very specific bodies and procedure engage in process to hold accountable high officials. In the other words, very specific bodies, institutions appears on the front line. We will talk about key institutions here. The first is Constitutional Accountability Commissions. No doubt it is a key institution in the chain of responsibilities of accountability issues in the area. It is totally separate body with huge and crucial opportunities. The Constitutional Accountability Commission of the same, this is our, in Poland, lower house of parliament, and Senate, it is the upper house of parliament, is a standing parliamentary commission appointed by the same. It performs, yes indeed, a quasi-prosecutorial function in cases concerning constitutional delicts of the highest officials. But crucially, the Commission itself is a body of ambiguously political origin appointed by the parliamentary majority. From the strategic procedural perspective, whether a trial before the State Tribunal will take place at all, it's largely decided by the political body wielding tools typical of the preparatory phase of criminal proceedings. The next key institution is a State Tribunal. It operates uniquely as a two-level court, ruling in both first and second instance without a cassation appeal to the Supreme Court. Additionally, this system is heavily complicated but extensive formal immunities. Basic evidentiary measures such as searches or seizing items often depend on political consent. This impacts the preparatory proceedings, which are divided in two phases. Phases in rem, gathering evidence about the event, and the in personam phase, bringing charges against a specific suspect. The dispute over whether initial in rem activities already require lifting immunity creates. In this way, we are approaching to the very interesting circumstances. From my observe, I call of this as immunity evidence paradox. Yes, indeed. We can call the immunity evidence paradox because prosecutors are expected to justify lifting immunity, but they cannot gather the necessary evidence unless immunity is lifted first. And I have a question. So, do you know very interesting and very clever book under the title Catch-22 by Joseph Heller, Paragraph 22 by Joseph Heller? Yes, I think all of us know substantive of this clever book. This immunity evidence paradox is functioning as a legal catch-22, straight out of Joseph Heller's famous book. As you may know, the book describes an absurd bureaucratic trap for World War II pilots. A pilot can be grounded if he is insane, but formally asking to be grounded to save his own life proves he is perfectly sane. It is a pure paradox. From a strategic standpoint in criminal proceedings, this hits at the very core of the issue. It perfectly illustrated how the defense can weaponize the catch-22 to paralyze an investigation before it even reaches in the personam phase, simply by blocking access to evidence right from the start at the interim stage. It is very perplexed circumstances. There appear next problem, structural and practical evidentiary difficulties. And at this point, we can move to the heart of my presentation. These are the main barriers to proving constitutional delicts. These are barriers of a structural and practical natures. So, barrier number one. The first barrier concerns entry into the accountability system. Both initiating proceedings before the state tribunal and lifting many immunities depend on decision of political bodies. For the president, the National Assembly decide. For most other senior officials, the same decide. The thresholds are high. It is necessary to gather a specific number of signatures on the motions and obtain a qualified majority in voting. In practice, this means that even with serious allegation of violation of the Constitution or statute, lack of political will can completely block the collection and evaluation of evidence by the state tribunal. Barrier 2. The second barrier came from this immunity evidence paradox, catch-22, paragraph 22 by Joseph Heller, what I mentioned. This touches mechanism from substantive and formal immunities. The procedural immunities of the highest officials means that the use of classic procedural measures such as searches, seizure of items, or temporary arrest requires the consent of the appropriate body. Often, this is the same political majority whose actions are the subject of the allegation. If we additionally adopt a broad interpretation of the concept of bringing to criminal accountability already including in REM activities, a well-known problem appears. Without prior lifting of immunity, it's not even possible to check whether there are grounds to file a motion to lift immunity. Similar dilemmas, where necessary protection of office ends and actual impunity begins, also appear in other countries in debates about parliamentary and presidential immunities. Barrier number 3. The third barrier is the collegial nature of many decisions. In constitutional delicts cases, we often deal with government resolutions, parliamentary majority decisions, or agreements within the administration. Proving that a specific minister, prime minister, or high official not only participated in this process, but consciously led a violation of the Constitution or statute is a very, very difficult task. Barrier 4, nature of evidence. The fourth barrier concerns the nature of the evidence. In constitutional delicts cases, documentary evidence dominates. Resolutions, notes, legal opinions, internal correspondence. Very often, these are material subject to secrecy clauses. Additionally, witnesses are usually connected with the current or previous ruling camp, which creates pressure for loyalty. Expert opinions are easily pretended as a politically motivated. Combined with the in dubio pro reo principle, this favors the conclusions that the evidence is insufficient. Barrier 5, clashing logic. The fifth barrier is meta in nature, in my opinion. This is the clash of two logic, criminal procedure logic and political dispute logic. Criminal procedure is supposed to serve the search for truth about the specific event. In practice, proceedings before the state tribunal very often very often criminal procedure is supposed to serve, in practice, proceedings before the state tribunal very often become another field of political conflict. Tools that in classic criminal proceedings serve to clarify facts are here sometimes used to block proceedings through dragging out procedures, not using the Commission's powers, lack of resolution opening the way to trial, or instrumental use of immunities. Against this background, we can see why, despite an extensive normative model, the number of actually proven constitutional delicts is so small. And consequences. The state tribunal practice shows a limited capacity to enforce accountability, highlighting the tension between immunity and impunity. While formal immunities are high political thresholds aimed to protect public officials from criminal law abuse, they frequently transform into tools that perpetuate actual non-accountability for those in high office. Whether a case reaches the tribunal or immunity is lifted depends more on the current balance of political forces than on evidentiary merit. In the long term, this erodes maybe public trust in state institutions and the principle of equality before the law, reinforcing the belief that political allies maybe operate entirely above the law. Direction of the change. First, the relationship between constitutional and criminal accountability must be clarified, eliminating the latest depends on the political will. For serious abuses of power, state tribunal proceedings should automatically trigger a criminal assessment by independent prosecutor authorities. Second, the immunity system needs rationalization. Formal immunities as exceptional protection must be interpreted strictly, cannot block basic evidentiary activities. In practice, routine in rem actions like court control searches or securing documents should not require prior lifting of immunity. Immunity should only activate when bringing charges against a specific person. The proposed shift to activate immunity only at the stage of bringing charges ad personam would force entirely new strategies in criminal proceedings. Law enforcement would gain early freedom to build strong evidentiary material in the rem phase. Consequently, the defense could no longer rely on political blocking the investigation at the outset, but would have to focus on a faster, purely substantive fight against the gated evidence and the final charges. So, conclusion. 3 conclusion lessons flow from the Polish experience. The first, hybrid accountability models require very clear rules for coordinations between the constitutional and criminal tracks. Second, political control over initiating proceedings must be balanced by the independent judicial control. And third, accountability for collegial decisions requires rethinking the standards for attributing guilt in conditions of distressed exercise of power. Thank you very much.